Welcome back. The Nkabinde Inquiry, chaired by retired Justice Booysen Gabindi, has continued this week in its investigation into the fitness of Advocate Andrew Chauke, the South Gauteng Director of Public Prosecutions, to hold office. The inquiry centers on allegations that Chauke made politically motivated decisions, specifically regarding the racketeering charges against former Hawks boss Johan Booysen and the failure to prosecute former crime intelligence head, that's Richard Mdluli. Let's dissect this development with Dr. Suhayfa Bhamjee from the University of KwaZulu-Natal. Dr. Bhamjee, good to have you on the program this evening. So, at the heart of the Nkabinde Inquiry is the question of a prosecutorial judgment. From a legal standpoint, how narrowly or even broadly should that discretion be interpreted?
Thanks, Nshlanshla, and to all the viewers, good evening. Thanks for having me back. This idea of, or the notion of prosecutorial discretion, it's actually quite wide, it's quite broad, but also within certain limits. And you can have a discretion to prosecute or discretion also not to prosecute. So in this particular circumstance, what we're looking at in terms of the Chauke inquiry was his pursuit of the racketeering charges in one case, which from Advocate Batoy's version for the NPA in the referral to President Ramaphosa was that was improper improper for the purposes of what the Director of Public Prosecution should be doing. And the second leg of that inquiry was related to the withdrawal of certain charges. And there is a difference between a decision not to prosecute and a decision to withdraw. But there is that discretion, and even that discretion must also be shown to be rational. If that discretion has been exercised irrationally, so even though there's lots of evidence and you're saying, well, I'm not prosecuting anyway, there are mechanisms for that. And I think what we're sort of either traversing here is, was it just poor judgment, or was it really an irrational, improper decision? As you said in your opening remarks, was it about politics on either side of the ladder?
Yeah. So Advocate Andrew Chauke is being scrutinized for decisions not to prosecute certain high-profile matters. Legally, when does a decision not to prosecute cross the line into misconduct, Dr. Bhamjee?
Okay, so that's a tough one to answer, because even if we weren't talking about high-profile matters, for example, we were just talking about, matters that aren't in the press necessarily. Where a prosecutor makes a decision not to prosecute, they have to then give reasons as to why. And to a claimant or the complainant on the other side, what they're looking for is a certificate nulla prosequi, which means these are the reasons why we are not going to prosecute. In other words, there is no case to be made here. Not even just there isn't a prima facie case. There's no evidence worth pursuing. This is a matter that is mala-fides, etc. And based on that certificate, it's not just we are simply not prosecuting, full stop. They've got to give full reasons as to why. So if a decision not to prosecute is taken, then we would expect similarly that's the reasons for deciding not to prosecute. There's no evidence, etc., etc. And again, is that distinction between withdrawal and a decision not to prosecute. The withdrawal means, for right now, we don't have enough evidence. We will continue investigating, and when we've got a more solid case, that's when we will come forward. Because remember, even if you proceed with a matter that isn't solid enough, what you're running the risk of is a finding of not guilty, which means the matter is closed now, it's done, it's dusted. You would rather strategically want to go with a stronger case rather than a half-baked case. And so you keep that door open when you say withdrawing. Withdrawing doesn't mean gone forever or gone or closed. It just means we're not starting it just yet.
Dr. Bhamjee, the inquiry is revisiting the failed racketeering case against the Cattle Manor unit. What are the legal thresholds under the Prevention of Organized Crime Act that prosecutors must meet before invoking racketeering charges?
Okay, so when we look at the POCA, when we look at that Prevention of Organized Crimes Act, there's really just three criteria, or three categories. The first one is, can you show an organization? And we think, as laypersons, we think an organization means lots of people. But from the Act, an organization could just even be one person, right? And then the second aspect that you're looking at, is the type of linking, that it's coming together sort of in a plan or in an organized fashion, right? So what you're looking at, so when we talk about organization or enterprise, that's your first aspect, but what we said was even one is sufficient for that. And then you're looking at the accused person's participation, what their role is. Now, their role doesn't have to have been the chief instigator or the chief organizer, if you will, but just that, how were they involved in the operation or the management of? So it doesn't have to be the sole person, but some level of able to steer and engineer. And the third characteristic is, well, is there a pattern? Is there a pattern of this racketeering? Now, so without this question of the third requirement of is there a pattern, so we're asking, well, is there an organization, or does it look like an enterprise as far as the definition goes? And secondly, this accused person that we're targeting in terms of racketeering charges, what was their role? And the third thing also linking it is the pattern. And so when we start thinking about what the original allegations were in relation to Chauke's misconduct, if you will, according to Batoy. And then we look at her testimony, in however little it was and incomplete. And now we start looking at Advocate Noku's testimony and Advocate Maema's testimony. Now we're starting to see, when we hear their version now, that it certainly looks like it's meeting that definition.
Yeah. So you mentioned the name of Advocate Sello Maema. So Advocate Maema testified that the prosecution failed because the legal test was not met. Does that necessarily then indicate a bad decision or simply a difficult, evolving area of law, Dr. Bhamjee?
So I don't think it was necessarily means a bad decision. Sometimes it also depends on, the quality of one's witnesses, etc. So there's a number of factors that go in. And like you rightly said, an evolving area of law. And even when we look on that question to Advocate Batoy's own testimony, when she did give testimony, she also said that the nature of these racketeering things is that it's ever evolving. Things change, more and more change. So if you were to revisit some of that, you'd definitely probably come to a very different conclusion. But based on what has been said so far, we do wonder how, exactly where the failings were in the presenting of that evidence that that case failed.
Yeah. Dr. Bhamjee, former KZN DPP Moiponi Noku insists that her authorization of racketeering charges complied with the statutory requirements. How much deference should be given then to senior prosecutors' judgment calls?
Well, I think we have to give them as much leeway for that. I think it was she certainly backed it up in her testimony by referring to things like ballistics reports. She was able to categorically state what informed her decision. What informed her decision. So I don't think there was it doesn't come across that there was arbitrariness or that her discretion was in a fettered way or in an unrestrained way or an unqualified way exercised. I think you have to give prosecutions and prosecutors the discretion to pursue difficult cases or to pursue challenging cases. Because if we were to say no all the time, or you are so limited, then we are going to just stick with or end up having only prosecutions for the cases that you absolutely can win, and those are the easy cases. Which means that these very complex matters, like racketeering cases, like organized crime cases, like state corruption types cases, will just be put aside. Why? because they're the hard ones to do.
With that said, and as we wrap our conversation as well, one concern raised by Shamila Batoy was Chauke's handling of sensitive cases, including that of Richard Mdluli. How central is consistency, especially in prosecutorial decision-making, to the rule of law?
It is central. It is absolutely central. I mean, we're talking about the rule of law because it creates what we'd say precedent, like cases or like systems or like are judged the same, and not just judged, but also the decision about, whether or not to even pursue a particular case. But that being said, each case is different. So we must also say, well, as much as we are setting and applying set criteria for decision making on prosecuting, we need to also have the lens, the human lens, the real lens, the reality lens, that in this particular case, there are certain nuances which inform the decision. And again, going back to the beginning, was it a decision not to prosecute, so like a nulla prosequi, or was it to withdraw and revisit at another time? I think that's what we would need clarity on.
Dr. Bhamjee, thank you so much for helping us unpack the legal and architectural behind what has become a deeply consequential inquiry. That was Dr. Suhayfa Bhamjee.